Hi, welcome to Ask Ann Anything, a show where we talk about real estate, credit, and consumer finance. Buying a home is one of the highlights of life. So much is involved in the process, but one area that doesn't get the attention it should is how to take title to property. By title, I mean naming who owns the house. We make assumptions about what will happen to our home and other assets should we encounter a life-altering event or when people are no longer living on this earth. However, the reality can be quite different. Today, we're going to talk to real estate attorney Kim Hughes, owner of KG Hughes & Associates. She will explain the two most common ways people title residential property and the ramifications of each. You will learn that how you title property is the most basic form of estate planning and is critical to ensure that your property is passed to those you want to have it. Thanks for joining us today.
Hey, Ann, thank you for having me.
We have a wonderful, wonderful topic that we're going to talk about, and it is what happens after you're gone. And that is so important because a lot of people don't stop to think about it.
Absolutely.
They don't. And, you know, I'm a real estate broker, and as I'm working with my clients, they're so excited about getting their home, but they give no thought to title, how it's titled. Nor have they planned for death. And that's because that's a subject that people don't like to talk about. Nobody wants to talk about death. They don't want to talk about dying. So to even have people consider writing a will when they, after they purchase real estate, we don't see that happening too much. And then things happen. And so, you know, I thought that maybe we might start our conversation out with just talking about titling. Because I think that's where it starts. I'm very well aware that as a real estate attorney, when you send the questionnaire out to the buyer, they're frequently asked how they're going to take title to the property. But the truth of the matter is that a lot of them don't understand the ramifications. What is the advantage of titling it one way versus titling it another way? So if we could have you start us off with just talking to us about how you take ownership of property, how it can be titled.
Which really is one of the basic forms of estate planning, right? Because when we buy real estate, a lot of times for many people, real estate is their biggest asset. So that's the thing, even before they start having a will, if they know how to title property in the way that they want it and the way that they understand the ramifications of their death will have impact on their family, their children, that kind of thing. That's a starting point. But if they don't even know that, just like you said, it can cause situations that they don't want. So how you title property is very critical. So most people don't know that there are what we call tenants in common. There are all various forms of way to title property, but the two basic ones that I want to highlight today is there's tenants in common, which means that if two or more people own the property, they each own 50%. If it's three people, they own a third, and so on. However, there's verbiage that should be placed on a deed if there's two or more people and they want to make sure that within those people who own the property, if something were to happen to one or more of them, then the other one would be the sole owner. That verbiage on the deed is called joint tenancy with rights of survivorship.
Okay, so let me stop you here because we're talking about, yes, in the event of a death.
Correct.
But I think the whole issue of titling even has to go, we need to think a little bit more because so often what I find, and a good example is like I had a person call me the other day, you know, their marriage is crumbling. They're considering divorce. One wants to sell the property, the other does not. And the one that wants to sell the property feels like they can move forward and has started moving forward to sell that property. And the other person called me and said, can they do that? And I said, no. So in situations where you have a married couple and they're either going headed towards divorce, how that property is titled is important.
Well, when it comes to what I just spoke about, that really doesn't matter when the two people are living, because as long as they're living, that ownership exists, right? So whether how it's titled as tenants in common or joint tenancy isn't relevant for that situation. So if you have a situation where two people are on title and they, like you said, are heading to divorce, unfortunately, then they have to make a decision as to what they're going to do with the property, and one cannot move forward in any way without the other's consent. So what's even most important in that situation is making sure that before people, because I get a lot of calls in my practice about people wanting to add people to title or to remove people from title, but they don't really understand the ramifications of that. I also had a situation where I was doing a closing, gentleman brought the property cash. Now he wanted to add his fiance to the title. And I just out of what I felt was good conscience to be able to say, well, sir, I want you to understand what that means, because if she wasn't there, this is the thing, she was in another state at the time. I want you to understand what that means. And if something happens, how that can hold you up from moving forward. Well, several months later, he calls and says, well, I want her off my property. I was like, well, she's got to sign something. If she doesn't sign a quitclaim deed to take herself off the property, then she owns it until she's willing to do so, if she's willing to do so.
Okay, so let's go back, because this is important, and we need to make sure our viewers really understand what you're saying. So let's say I'm dating this guy, and we've been dating for 2 years, and I just know we're going to get married. I love him. I can get a home. Right now, he can't qualify for a loan. I'm going to get a loan to purchase our home. But because we're in love and we share everything, I want to put him on the title. So what you're saying, in essence, I am on the title and he's on the title. But I am the only one on the note. The note is where I promise to pay the lender their money, correct? We break up. What happens?
He's got to sign and quitclaim his interest back to you.
But the chances of that happening are none. And I had a situation where there was a gentleman who, same scenario, put somebody on the title. They broke up. They never even made it. They never even got married. They broke up. And he was forced to sell the house and give her half of the proceeds. So that's a dangerous thing to do. You need to understand. You can't get caught up in emotions.
You can't.
Because emotions are what lead you to make a unwise decision.
And it's getting to a point where I just feel, and I've seen it, you know, I've been practicing over 25 years. I've seen so many different scenarios. And the one thing that I think happens is, like you said, the emotional component, just in life in general. And when it comes to property, because again, like I said, this is one of the biggest assets that a lot of people have in their lives. Do not put yourself in a situation where you're stuck. That's really the situation, because, I mean, you can be in love with someone, you can get married and still not add them to the title. You can put that in your will. Put yourself in a situation where you're thinking beyond the here and now. So, for example, if you get married to someone and say it's new or what have you, but you're able to get the property. Now, there are situations, and let me speak to this too, because you and I, because we do business together, we've come across this situation a lot. In Georgia, people think that just because somebody gets a property in their name with a loan, that they can just automatically add someone else to title. But in the security deed that they sign in this state, they have to get lender permission. Otherwise, the lender could call the loan due. So that provision is in every security that we have, at least in the state of Georgia. And it may be similar in other states, because I know the audience is broader than just Georgia. But it's something that people need to consider. Now, there's a reason for that. There's several reasons for that. But the one thing that I think people need to realize is that if only one person was able to qualify, there may be a reason for that. There may be a reason why the lender did not want someone else to be added to the property. But in order to make sure that you're thinking about that loved one or that child or however, prepare a will, a simple will. If something were to happen, then would cover and protect their interests. But if you don't have a will, then yes, it opens up other problems.
But you know what, you just said something that I don't even think that I really thought about it. A lot of attorneys, when they send the questionnaire asking the buyer to identify how they want to take title, there's never an explanation.
Correct.
You know, they just check. But you said something that might, to all of you out there who are listening, you might want to consider. Add them to the will, but don't add them to the title.
That's right.
And you mentioned another word. I want them to understand what it means, and I got my little way of saying it. Is the security deed. So you have the title, which are the two people or whoever owns the property.
Right. That's ownership.
That's ownership. You have the note. That's who has to pay for it. But the security deed is another document that is signed at closing, and that says who has the right to take that property if you don't pay. Is that the best way to say it?
Well, I think the best way to say it is that's the lender's way of protecting their interest in the money that they're lending a borrower. You know what I'm saying? So because they're lending hundreds of thousands of dollars.
You're saying it the legalese way. I'm just saying it the regular way. Those are the people, the lenders who can come and take your property if you don't pay.
But it's not a person, it's a company, it's an entity. So that's why I want,
I got you.
Yes.
So we're clear on that. So I just want to make sure everybody understands the terminology.
Right.
All right, good. So we understand why how you take title to a property is important. And if you love somebody, but you really feel like in the event of your demise, you want them to have the property, the best thing for them to do would be to add that person to a will.
To a will. And let me touch on something else too, because even outside, like I said, I get a lot of requests, especially now with COVID and all of that. I think people are just thinking through things more. I get a lot of requests because people want to add people to title. But you also have to know that if that person has liens, judgments, potential lawsuits, anything like that, if you add that person to title on your free and clear home, or even if it's not free and clear, you inherit everything that comes with them. So that means if there's liens, judgments, or anything like that, which I have seen these situations, thousands of dollars, you try to go sell your house, you have to pay, even if it's not you, whoever you added to title, you have to pay their creditors.
Important.
Yes.
I had a client once who, solid marriage, married 30, 40 years. She was able to qualify for the loan, wanted to add her husband to the title. Makes sense.
Right.
And I remember just saying, is he current on taxes? He hasn't filed taxes for about 10 years.
Right.
I said, sweetheart, I know you love him. Y'all gonna be together till you go home and be with the Lord, but you don't want to add him because by him being on that title,
that's correct,
then a lien can be placed on that property because he owns the property. That is something worth thinking about.
It's absolutely, where if they had a will, none of that attaches.
Exactly.
None of that attaches, at least until, now once you put title in their name, you know, so if somebody goes through probate and an executor, if there was a will, then once you put title in that person's name, it can attach. But at least while it's going through probate, they may have to be disseminated to other people to prevent that type of situation. But at least, again, you're not putting the family in a situation where they're stuck. You know, and really what this is saying too, outside of the nuggets that we're going to be giving, people need to seek legal counsel.
Okay.
They really do. A lot of times especially now you can Google, they think all of that can give them the proper answer to handle their personal and their financial affairs. It's not. Seek professional counsel whenever you're making a major decision that's going to impact you. Because I've seen people do things and it messes them up.
And I'm going to tell you where else, since we are talking to a national audience, even this issue of child support. Because in some states, if you owe child support, you can have a lien placed against you. I don't know if you're aware of that. I was reading that.
Yeah.
Laws differ from state to state.
Yes.
So you might want to find out. You may be in love. I get it. Y'all are going to be together forever. I know how that goes, okay? I know what people say when the emotions come into play.
Right.
But he doesn't have to know you're seeking legal counsel. Just go.
Absolutely.
You just go talk to somebody.
That's right. Absolutely.
Before you add them to title.
Yeah, especially if people are not married. If they're not in a legal contract You shouldn't be talking to anybody outside of when it comes to your financial affairs, unless you're preparing to get married. They shouldn't know all of that, because anything can happen. I've seen it too much. And there are people who prey on people when they know that they can, there are people who are very smart in their financial affairs, but not so smart when it comes to thinking about how to protect themselves and the emotional part of it. And people can take you. I've seen it.
Seen it happen. Many people have financial questions and they don't know where to get answers. Now you do. We want to be your resource by providing you with educational information in a way you can easily understand from people you can trust. I invite you to send your questions to Ann at askannanything.com. Your questions form the basis of our show. Additionally, we offer live Zoom educational classes on home buying and credit that you will want to take advantage of. Remember, home buying starts with planning. For more information or to register for our course, go to askann.com. Now, if you enjoyed today's show, please click like and submit. I look forward to seeing you next time.